Good evening, everyone. Welcome to the event. We are holding a book discussion on a book written by Mr. Hrishikesh Chavan, which is titled Stages in Criminal Trial. So, as you know, trial litigation is a lot of focus is there because of the pendency and backlog and many other things. So, we thought we'll organize a discussion around it. It's published by All India Reporter. And about the event, it was planned as a very small event in a small cozy auditorium like this one in the evening, where we thought we'll invite mostly our friends, as such. So that's how we started. So the people behind it, I'll start with Rahul Hingmire's firm, Vis Legis Law Practices. So it's a big support which they've provided for this event. And CETAR is a small platform to do small events and small things. And we hope to spread the message of arbitration and trial advocacy and do some empirical research in it. So that was the thought. And All India Reporter, as you know, is the premier journal of law reports in India, started from 1914 onwards. That's where we have as a record of what happened in the courts, through the reported cases. So I welcome you again here. We have our dignitaries here who are experts, Hon'ble Mr. Justice Tahaliyani and Mr. Subodh Desai, Senior Advocate, have come. I'll give a more detailed introduction as we proceed. But and I also welcome you all because it's Thursday evening. You have taken out time from your busy schedule and have come here. So before I jump into the program, I would like to introduce Rahul Hingmire, and he'll do a more detailed welcome. But before that, I also welcome Madam Swati Chavan, who has been a formal principal judge of the family court in Bandra. Welcome, ma'am. So let me introduce, without much further ado, Rahul Hingmire. So Rahul is a co-founder and managing partner of Vis Legis Law Practices. He specializes in civil and commercial litigation and alternative dispute resolution methods. His primary focus is on proceedings under the IBC, where he has represented both the financial creditors and corporate debtors. Talk about being on the both sides. As such, before various national law, company law tribunals, NCLTs, he has also successfully handled complex commercial transactions and proceedings before multiple courts and tribunals across India. Mr. Hingmire regularly advises real estate companies, cooperative housing societies, and investors in the real estate sector. He has completed his graduation from the DES Law College. So his first degree is from DES Law College, which is part of University of Pune. And he pursued his post-graduation at the University of Nottingham in England. He has been enrolled with the Bar Council of Maharashtra and Goa since 2009. In addition to his professional practice, Mr. Hingmire serves as the chairperson of the Arbitration Committee of the Maharashtra Chamber of Commerce, Industry and Agriculture, which is where we are, whose auditorium this is. It's a 100-year-old organization as such. So I'll hand over to Rahul to take it further. Thank you very much.
Thank you. Thank you, sir. Thank you, everyone. Welcome to the event that we've been looking forward to and planning since last few days. This is a book discussion on the book called The Stages in Criminal Trial, Concept, Principles and Practice by Hrishikesh R. Chavan. At the very outset, let me clarify to everyone that this discussion is in furtherance to the formal launch that had taken place last month at Nagpur by the Honorable Justice Prasanna Varai sir, Judge of Honorable Supreme High Court, where he we are deeply grateful for sir's presence at the occasion, not only the presence but also a thoughtful forward that he has given to the book that captures both the urgency and the clarity with which this subject has been handled by the author in this book. Now, we are also very fortunate to have with us Honorable Justice M.L. Tahaliyani sir, who has been widely respected for his distinguished career as on the bench, where he has particularly handled some of the most sensitive and high-profile criminal trials in India. His judgments reflect clarity, balance, and fairness, these qualities that continue to inspire many of the lawyers across generations. His presence today brings immense weight and credibility to this discussion that we are going to have in today's session. Alongside with him, we are privileged to have designated senior advocate Mr. Subodh Desai, a leading name in criminal practice, known for his advocacy in complex and high-stake cases, and his practical courtroom insights complement the judicial perspectives, reminding us that the justice thrives when both bench and bar perform their roles with integrity. Together, their presence makes this discussion especially meaningful. This gathering is about the book launch forward, reflecting, exchanging ideas, and exploring the insights Hrishikesh has offered at the pivotal time for criminal law. As you know, for the first time in decades, we are transitioning between the two regimes of the Code of Civil Criminal Procedure Code of 1973 and the Bharatiya Nagrik Suraksha Sanhita 2023. This shift affects every legal practitioner, litigant, and the judges. Hrishikesh's book, therefore, arrives as both timely guidance and a scholarly contribution. This book carefully explains the stages of criminal trial from in the beginning part to go with, that is inquiry and investigation, to taking cognizance, to arrest, bail, charge, plea, evidence, rights of accused, convictions, sentencing, as well as appeals. It is certainly a curtain raiser for every young lawyer stepping into criminal practice, and while it also serves as a crisp reference for all those who are already deeply involved into criminal law as a professional. What makes this work even more meaningful is that the judicial guidance and the lineage behind it, because Hrishikesh has drawn inspiration from Justice R.C. Chavan sir's background, whose clarity in legal criminal jurisprudence continues to be the guide for the legal fraternity. This book reflects Hrishikesh's scholarship and practical experience while building upon Justice Chavan sir's legacies of clarity and commitment to the law. I must also say how personally special this venue is for me. As the chairperson of Maharashtra Chamber of Commerce's Arbitration Committee, it gives me immense pride to host this book discussion at the auditorium of Masai. We fondly call it Masai, Maharashtra Chamber of Commerce, which is in its 90th year of its establishment and which stands as one of the oldest and most respected chambers in the country. This newly inaugurated office and auditorium represents not just as a physical space, but a vision of bringing together law, industries, and academia. I must also take a moment to acknowledge Advocate Hasit Seth sir's contribution, whose tireless planning and coordination ensured this event was executed with dignity and at this scale, despite that his commitments and demands of his courtroom practice across India. His commitment is deeply appreciated, sir. So friends, we open this discussion. Before we open this discussion, let us remind ourselves that each stage of criminal trial is just not about procedure. It is about liberty, fairness, accountability, and ultimately justice. This book captures that essence and gives us an opportunity to reflect on this together. On that note, I once again welcome you all, and I look forward to exchanging the ideas and understanding the perspectives that will follow in the discussion. Thank you so much. Thank you.
Thank you very much, Rahul, for the very comprehensive introduction to the book and the dignitaries who have blessed this occasion by their presence here. And we'll shortly get to hear them. But before that, I need to do something important, which is felicitate our guests. So instead of the usual flowers, we have chosen plants. I mean, to felicitate this thing, because this is also the monsoon season, which is around us. And I'll request Mr. Hrishikesh Chavan advocate to felicitate my Lord Mr. Justice Tahaliyani. May I request Mr. Rahul Hingmire to felicitate Senior Advocate Mr. Subodh Desai with a plant. Yes. May I request Associate Partner of Vis Legis Law Practice, Madam Radha Ved, to felicitate the author, Mr. Hrishikesh Chavan. And may I request Sharmishtha Patil, advocate, to felicitate Rahul Hingmire from Vis Legis. Can I request Rahul to felicitate Swati Chavan ma'am also? As such. Ma'am, please come on the dais.
Thank you.
We have next scheduled Mr. Hrishikesh Chavan, advocate, whose book we are celebrating today and will be discussing the stages in criminal trial today. So I'll introduce Mr. Hrishikesh Chavan in a little more detail, although Rahul has had some words to speak about his background. So he's a lawyer practicing in Mumbai with over 15 years of experience. He began his law career with a firm Bachuvai Muniman Company, where he practiced litigation with a focus on civil, commercial and corporate litigation. Next, he joined the Chamber of Eminent Criminal Lawyer, Mr. Subodh Desai, who is here as his senior and now senior advocate designated by the Bombay High Court. And under guidance of Mr. Desai, he appeared in number of criminal cases at different forums at various stages of criminal trial. He has handled matters. Later, he started his independent practice with his own chamber, where he has appeared in a number of different kinds of litigations and forum, and his special interest is in the practice of constitutional and criminal law. He is empaneled with the Bombay High Court in their panel of arbitrators. He has degrees in law and also management. So he is a gold medalist in LLM and also an MBA. So I request Hrishikesh Chavan to come and give his address next.
Thank you, Hasit sir, for the kind introduction. Good evening, ladies and gentlemen. Honorable Justice Tahaliyani, former judge of Bombay High Court, who is like a father figure to me, whose courtroom was always a learning experience for most of the lawyers from my generation. And no lawyer ever walked out of his courtroom disappointed, irrespective of the outcome of the case. Further, when it comes to criminal trials or criminal law, with the mammoth experience which he has as a judge, he is no doubt an authority on criminal law. Guest of honor for today's function, my mentor, my coach, my guide, my teacher, my guru, Mr. Subodh Desai, Senior Advocate, Bombay High Court, who presented me with an opportunity that helped me learn and unlearn things in law as well as beyond it. Mr. Rahul Hingmire, Managing Partner of Vis Legis Law Practices, who has swiftly orchestrated today's symphony of discussion. My friend Advocate Hasit Seth, who has been an elder brother to me, whose chamber is right next to me, and that is one of the reasons why I don't wish to leave my chamber. and it's a selling point which thankfully my landlord doesn't know. He's not aware about it. Distinguished guests in the audience, Swati Chauhan madam, former principal judge of family court, my dear colleagues from the bar present today, it is said that a man is known by the company he keeps. I won't have been able to write had I not been in company of some really good and wonderful lawyers and human beings present today. Authoring this book was no less than an odyssey for me. It only made me a better student of law. With the book already released, it is a sense of satisfaction, a feeling of accomplishment. Release of this book is a reflection of the fact that I continue to be in good company of lawyers. It is very difficult for a rookie coming out of law college and straight jumping into the court with a brief in his hand. Everyone is not fortunate to have a senior like Mr. Desai to guide, or for that matter, a judge like Justice Tahaliyani to protect and correct a junior. See, committing errors, we are all humans, we are not immune to errors. So we need someone to guide, correct and protect. The idea behind writing this book was really to bridge the gap between the academics and the practice in the courtroom. In the college, we understand what is a particular provision, but when we practice law, we understand why that provision exists. So linking academics to practice was the main motive behind writing this book. The book is structured depicting different stages in criminal trial. The life cycle of criminal litigation is depicted. In the book, if you come across references to Mr. Q, Mr. M, Miss Moneypenny or James Bond, consider yourself to be part of Bond movie. The idea was to make reading enjoyable. The illustrations use those characters in the book. The language, I have tried to make it very simple, use minimum jargons in the sentences so that even a person who is not from legal background, legal profession can understand. Well, considering the esteemed guests today we have, it would be only proper for me to speak less and listen more. Additionally, the book is already there and all my views and opinions are there in the book. Nonetheless, I will quickly take you through the chapters in my book in a poetic way. Hopefully, you will like it. Be it a Mughal, a Sultan, a Maratha, or a Peshwa, history tells that rulers ruled the rule of law. Yet the Indian judiciary was known for its independence. For the Indian rulers, although not elected, had conscience. Westerners drafted comprehensive laws to rule. They devised the court machinery like a rein to pull. Releasing the rein, they left wonderful draft of literature for us to sustain. Tampering with this English literature, we tightened the rein again. Courts we have here, courts we have there, more and more courts we have everywhere. Some try petty offences, some grievous crimes. Magistrates or sessions, both have their own rhymes. Police, high court or magistrate, for setting law in motion, open appropriate gate. Boarding the right gate would redress your grievance. Read chapter 4 for the right lessons. Inquiries and investigation are the next. Magistrate and police, along with lawyers, are put to test. Patience is the key for all the stakeholders here. Chapter 5 makes the difference between inquiry and investigation clear. Next comes a topic which appears to be very basic. Cognizance is the word that heads chapter 6. Courts have interpreted cognizance to suit their convenience. No one understood it. Even legislature skipped it from definitions. Bail is the rule, jail is the exception. This must be the most ever argued contention. Arrest is a process which curtails liberty. Discretion here is to be administered with comity. Charge must be framed upon reading entire material, as it is most important stage because man starts facing the trial. Court should be cautious and decision must not be hurried. In zest of disposals here, justice should not be buried. Plea is an opportunity for the accused to decide. He must inform the court if he claims to be tried. Plea bargaining in past was discouraged by courts in India. It's time that system must remove this plea bargaining related phobia. Many procedures ancillary to the trials used sometimes as strategies or sometimes as cures. 10th is a chapter depicting lot of possibilities. It is a good exposure to academicians of realities. Witnesses are humans with feelings, so they may turn hostile. Examination of witness is an art. Your brain must be agile. Lawyers must know what storyline to follow. Some ideas from the appendix of the book you may borrow. In chapter 12, we go to some fundamentals and basics. Prosecution must discharge the burden to convert accused into convicts. Accused have rights from remaining silent to double jeopardy. Such rights are important to maintain the trial's sanctity. 13 brings us close to the climax. Give judgment with fairness and relax. Sentencing is equally important and its hearing is separate. Deter, retribute or reform to decide the assailant's fate. Anything and everything under the sun can be challenged. Looks like law is for lawyers. Nothing has changed. Writs are the immortal remedies used by legal fraternity. 482 is now known as 528. Only the name has changed, not the paternity. Thank you very much.
Thank you very much, Hrishikesh, for the very poetic introduction to his book and the contents of the book. And I presume that, somebody who's read this book will also conduct a criminal trial in a poetic fashion. Such, and hope it goes that smooth. As such. So I now have the privilege to introduce our guest of honor today, Senior Advocate Mr. Subodh Desai. So Mr. Desai is a Senior Advocate of the Bombay High Court. Mr. Desai started his practice in the chambers of my Lord Justice Dhananjay Chandrachud, now the former Chief Justice of India. And his practice then focused on writ and constitutional law. Later he joined the chambers of Senior senior advocate Mr. Shirish Gupte, very focused on criminal litigation in his practice. Mr. Desai has appeared in almost all high courts across India. That's something to say. I mean, of a wide experience. And various trial courts, he has appeared also across India. He has worked as a special public prosecutor, covering some key corporate matters as his role. He has also appeared as a special PP for Union Territory of Dadra and Nagar Haveli. Further, he has also appeared in the Bhopal gas case. I don't know how many remember that, the deadly methyl isocyanate gas, gas led to so many deaths. Mr. Desai graduated in philosophy, and interestingly, he has a gold medal in mono acting in the Mallar Intercollegiate Festival, which I think is an amazing side to his personality. So, may I request our guest of honor today, Mr. Subodh Desai, to address us on the stages in criminal trial. Please, sir.
Thank you for the nice words, Mr. Seth. The most respected, the Hon'ble Mr. Justice Mr. Tahaliyani, sorry. The erudite author, Mr. Hrishikesh Chavan. The host, Mr. Hingmire. Mr. Seth, who has organized this. The dignitary, Ms. Chavan, participants, ladies and gentlemen, friends. I must say that it's exalting and overwhelming to share a platform with the Honorable Mr. Justice Tahaliyani. He is, and which was pointed out by Mr. Chavan, he is a living encyclopedia on the subject matter which is under discussion today. You can call it whatever, a Wikipedia, you may call it a mine of treasure, but he is everything that could be there. And then to be a speaker with him on the platform, it reminds me of what Abraham Lincoln once said. He said, and I quote him, he said, "It is better to remain silent and be thought to be a fool rather than speak out and remove all doubts." So, I am going to keep myself very brief today. So, coming to the book, let me first congratulate Mr. Chavan, because I have not got the opportunity to publicly congratulate him. Hrishikesh, that book is a masterpiece, and I will say why it is a masterpiece and why it is so different from the other books which are on the same subject. So you may come across Hrishikesh as a very soft-spoken, silent, and a subdued, gentle soul. But underneath that, you'll see a raging fire of a scientific inquiry, a quest for knowledge, a thirst and a hunger for legal acumen. And that has been translated in this book. And why do I say it is a masterpiece? Because this book is not only for laymen, it is also for practitioners and is also for students. When I say that it is meant for all these people in one sweep, it is because when you start reading that book, you realize that it satiates one's inquiry on a topic, which he's dealt with all these topics, but at the same time, it fuels a quest to go deeper and delve deeper into a particular topic. So, as a matter of illustration, I will point out the first chapter itself, which is in respect of the history of criminal trials. Now, he starts with the Chandragupta Maurya period, that is Kautilya Arthashastra, comes down to the Mughal period, uh, uh, I think Fatwa-e-Alamgiri, comes to the Maratha period, the Peshwa period, then the British chapter of Warren Hastings, of Macaulay, then he goes to the Bengal chapter, the High Courts, so on and so forth. But what is it that is conveyed through all this history? It's just a 4.5 page approximately of a chapter. But through all these eras, all these centuries, there's a common thread which has been pointed out by Mr. Chavan. And that common thread is this, that whichever was the era, whatever was the culture, whatever was that those centuries apart, things remained nearly the same. What was that? 1. Impartiality. 2. Independence of judicial dispensation system. 3. The principles of the philosophy of sentencing and punishment, so on and so forth. So once you start reading it, your inquiry is satiated so far as understanding history is concerned. But what kicks out is that quest to understand, go deeper into that historical perspective of law, so that you get a grasp over that thread which runs through eras, to centuries, so that the author kind of teases you to go ahead and delve deeper into it. That is what makes a difference between this book and the other books. The other thing to the book which I found is very interesting is in the title itself. The title talks about the concept, principles, and practice. So let us all be very clear. Unless we have the basic concepts, unless our basic concepts are clear, unless we really know the first principles, it is going to be very difficult to put it in application for practice. So these concepts is what has been sought to be put forward by Mr. Chavan. As a matter of illustration, and that is where I think he also pointed out, in a very innovative manner, he is dealt with the concept of a charge and discharge in a criminal trial. And for that purpose, he has used the concept of James Bond, of Miss Moneypenny, Mr. Q. And during that entire reading of it, where a person gets involved in the entire innovative illustration, you realize as to what is a charge, what is the concept of alteration of charge, and where does discharge fall within that entire thing. So once your concepts are clear, it becomes far easier for you to approach a subject, a topic, and go towards the ultimate quest of justice. That is also what is understood of the principles that comes on the title of the book. Because if you go to a chapter of evidence and cross-examination, as well as the chapter on proof, the last chapter, 12th chapter 12, I think it's proof of burden of proof. So if you go through it, you will realize that the principles which are required to really understand how the process works in a trial is what is brought forth by Mr. Chavan. That is the distinguishing factor between these books, the books which are there and the book which Mr. Chavan has authored. There's one more aspect to the book, is the critical approach he's taken in for certain provisions and chapter, and one of it is plea bargaining. A very interesting concept where he's charted out the manner in which plea bargaining came into being in the US courts, how it has been borrowed by the Indian legislation, how it has been considered by the Supreme Court of India, and what, after this consideration by the Supreme Court, what would be the relevancy of this in the present scenario, is what has been urged by him in his book, because this entire chapter has been continued in BNSS as is, without any changes whatsoever. So that is what really sort of makes a person start thinking. This is what is the entire, I believe, the book which makes you think, gives you the concept, gives you those first principles, and urges you to go deeper into a topic, to make you a better lawyer, to make you a better, to get you a better understanding of law. All in all, I would say this, that the book is very well structured. It demystifies law for laymen, because as he said, the jargon is really removed. The language is very simple. Anybody, any lay person can understand it, the basic concepts and principles of law. It deconstructs provisions of law for students. So it is a deconstructed format where they can build upon a form. And it also enables a practitioner. So the book is really unique in that manner. So I feel that each one should have that book in his personal library, and please read it time and again, because every time you would read that book, you would have a new perspective to the concepts of law, the principles of law. I think I should remind myself about Abraham Lincoln, and that is where I should stop. And I thank Mr. Seth and Sitar for inviting me and being a part of it. Thank you.
Thank you, Mr. Desai, for the illuminating views and in-depth way in which he conducted a review of a book. Usually a book review is in a written form, but here we saw how a book review should be done in an oral form as such. So thank you very much, sir, for it. Now I have the utmost privilege to invite our chief guest for his address after I introduce him. My Lord Honorable Mr. Justice Tahaliyani is a former Lokayukt of Maharashtra and of course a former judge of the Honorable Bombay High Court. Justice Tahaliyani presided over high profile cases including the 2008 Mumbai attacks and the Adarsh housing scam matter. Justice Tahaliyani began his career as a lawyer in the Vidarbha region of Maharashtra in 1975. I was born in 1974, so you can imagine how much of like practice he had, and then his judicial experience. After a few years, he was appointed as an assistant public prosecutor in the Naxal affected area. And then he was appointed as a metropolitan magistrate in 1987. Justice Tahaliyani was later appointed as the additional chief metropolitan magistrate in 1994, and further later in his career as the chief metropolitan magistrate in 1997. In 2010, he was appointed as the principal judge of the Bombay City Civil Court and the Sessions Court. And in the same year, while presiding over 2008 Mumbai attacks, he pronounced the death penalty to Ajmal Kasab on terrorism-related charges. The judgment was later confirmed by the Bombay High Court, and upheld by the Supreme Court, after which Kasaf was hanged at the Yerwada Central Jail in 2012. The following year, Justice Tahaliyani was appointed as a judge of the Hon'ble Bombay High Court, and he also then presided over the Adarsh Housing scam inquiry. So I have the privilege of welcoming Mr. Justice Tahaliyani for his address.
Thank you, Mr. Seth, for introduction. Learned Senior Counsel, Mr. Subodh Desai, Madam Swati Chavan, Mr. Rahul, Mr. Hrishikesh Chavan, I may call him Rishi, and young lawyers in the audience. I never knew that Rishi is writing a book, because as Mr. Subodh Desai described, he is not, his outer look is not of that kind of person. But something seriously is hidden in him that I came to know when his father disclosed to me that he has written a book. This type of book was necessary today because the young lawyers who come to bar, they feel sometimes helpless on the minor issues like bail application. This reminds me of the incident when I completed my law and started practice. It was my second day of my practice, and I had a client who wanted me to apply for bail, and it was holiday. And I even did not know that holiday magistrate is available at his home. And somebody came to me. I was staying with my cousin. It was afternoon time. Bail के लिए apply करना है. So it was a difficult situation for me. How to write bail application? I said this type of books are necessary because I was not knowing how to write bail application. So my immediate neighbor was Advocate Katre, a very senior lawyer. I went to him. He gave me a paper and pen and dictated the bail application. I only gave him the name and the offence. And I went to the magistrate's residence, Mr. Dongaonkar, who later on became High Court judge. He was magistrate that time. And he had predicted that I would become judge in his open court. So I went to him. He offered me a glass of sharbat, sikanji, and granted bail. So I was very happy that bail. I think the client gave rupees 50 or something like that. So what is relevant is that the book which is written by Hrishikesh, Stages of Trial, he has dealt with bail also, charge, discharge, plea bargaining. So these issues are not known to the lawyers young lawyers when they come out of the law college. I'm very sorry to say, unfortunately, the pattern of teaching in general law college, not very high profile law colleges like National Law College or Government Law College, is not of that type that lawyer who is coming out of the college shall become a lawyer within a few days. It takes years for him to become a lawyer. So that, I think, must be in the mind of Hrishikesh, to cut short that period to become a real lawyer and practice in the court. Because to appear in the court, when they come out of the law college, it becomes very difficult for them to appear in the court unless they have knowledge of all these things with them at that time. And this book is a comprehensive book guiding them on all the subjects, like plea bargaining. Many of the young lawyers, they don't know what is plea bargain. And unfortunately, there is no bargaining for the accused. Am I right? I have not read that plea bargaining since many years, but I remember that there is nothing for the accused to bargain. He has to plead guilty and leave it to the discretion of the magistrate. So I think he should have highlighted that point in the book. He has not highlighted. Because when you write another book on the criminal law, you highlight what is there for the accused to bargain. He should have a right to bargain कि सर आप यदि मुझे ऑलरेडी अंडरगन और एक महीने की सजा देते हैं तो मैं कबूल करता हूँ. But that is not there. If bargaining power is not with the accused, where is the question of plea bargain? So these are the things which the young lawyers don't know. And unfortunately, as I said, the teaching pattern in the colleges is not that. They should make them a practical lawyer. I don't know in how many colleges there is the professor on law of crimes or professor on CRPC tell them कि how bail application is drafted, how it is to be argued, what can be argued by the prosecutor, and what should be your reply to the prosecutor. And you don't get all judges like Tahaliyani. That is again the problem, not law. So when you are not before the judge who is not Tahaliyani, then you need this book with you. If you are before me, then it's okay. I'll take care of everything. So, young lawyers, what Mr. Rishi has done in this book, chapter-wise review has been taken by Mr. Subodh Desai. But the way he has written the book and the chapters he has given one by one, even if you don't read the book from the beginning, if just go to the chapter of discharge, you will be able to follow what the author wanted to say in this particular chapter. There are many judgments. The problem with young lawyers is that they cannot, assert themselves too much in the court. So young senior lawyers can assert. But young lawyers, they find it difficult to assert too much in the court because they are scared of the judge that he may misunderstand him. Or he may take, he is trying to be extra smart. So though he has a guts to be extra smart, but he cannot because his practice is at stake. So the judge's responsibility is to take care of such young lawyers. And as I said, you don't get all such judges. All judges like Tahaliyani, therefore, you have guts and you have to assert. And if you want to assert, then you need knowledge. If you need knowledge, then you need to read the book. Knowledge doesn't come automatically. And we all should be thankful to Rishi that he has written a book in such a manner that if you read that book carefully, you assign some part of your day for reading that book. After some day, after few days, or we may say a month or so, you will be able to understand the procedure of criminal trial. He has described it in stages. Once one of my colleagues, I was in Sessions Court. I was, of course, mainly on criminal side. My colleague was on civil side. And Mr. Desai must be knowing that civil courts were on the second floor. So just we were talking. So my colleague said कि क्या फिफ्थ फ्लोर पे बैठ के काम करते हो, सेकंड फ्लोर पे बैठ के काम करके दिखाओ. So what do you mean to say? Second floor was civil court. So he thought that civil is difficult and criminal is very easy. Criminal cases to handle are very easy. That is what his feeling was. I told him, कि Mr. You are running a goods train. I am running a passenger train. If your train is derailed, what will happen? some goods will be spoiled. If my train is derailed, somebody may go to gallows unnecessarily. So don't consider criminal law to be so simple. It is very interesting but difficult. Appreciating evidence of a witness in criminal law is very difficult as compared to civil law. Because civil law, you have a plaint, you have a written statement, you have issues, and then you have some issues already decided, you have issues of plaintiff, you have issues of defendant. Some issues do not survive. So in criminal law, that is not the position. Criminal law, you see, the prosecution has to prove each and every fact beyond all reasonable doubts. So when you are practicing on criminal side, it is not that easy. Understanding the psychology of witness is not that easy. Mr. Desai has been practicing in criminal courts, trial court also. Hostile witness. Young lawyers are nowadays very happy if the witness is hostile. They don't try to understand if the judge is good, means he is really well read. He will not reject the evidence of hostile witness in wholesale. He will try to find out what is there in his evidence which is admissible, though he is hostile. So one has to be very careful while handling the criminal cases. Take a case of discharge. There is a lot of difference between prima facie case and case not fit for framing charge. That I believe that you must have included in your book. So these intricacies of criminal law, once you understand, that I am telling from my experience, once you work on any issue which is very difficult carefully and you grasp it, you don't need to read it throughout your life unless there is some judgment from the Supreme Court which changes your view. Or I may say, which changes their own view. So, in civil law, there is one side represented by a competent lawyer, other side is also represented by the equally competent lawyer. The case of the defendant is disclosed. In criminal trial, the accused has right to keep mum till the end of the trial. But at the same time, the accused must know at which stage he has to speak out. Like a defense. Suppose accused has taken a particular defense. Specific defense is taken by him which is within his exclusive knowledge. Then he has to disclose that this is my defense. Now there is an X defense which is exclusively within the knowledge of accused, nobody else knows. The law of evidence says that that is exclusively within his knowledge, he has to disclose. But at the same time, other defenses which are available to the accused, they are not necessarily to be specifically pleaded, which is not the case in civil law. Civil law, if there is nothing in your pleading regarding what you are now telling in the court in evidence, that is not accepted. So you have to plead that I claim adverse possession. But in criminal law, if you plead private defense and if you don't tell the court that I am taking the defense of private defense, but your private defense is available in your cross-examination, the judge cannot refuse to take cognizance of that particular fact. Judge may say, from the cross-examination it appears that it was a case of exercise of right of private defense. So these intricacies are there in the criminal law which Rishi has tried to encompass in one book. And once you start reading book, The beauty of that book lies in the fact that it instigates you to read another book. Another book in the sense, the detailed case law. If he has referred to a case law state versus XYZ, then you should have urged to read that case law. Because he at the most can write 1 or 2 sentences of that judgment in the book. But you get that complete idea after reading the judgment. So the beauty of his book lies in that. Once you start reading it, as Mr. Desai said, your quest for knowledge, it increases. And legal profession, I tell you, there is nothing more than knowledge. Unless you are knowledgeable, you are not respected in the court. You can assert yourself in the court if you have a grip over your matter on facts and law both. If you assert yourself in the court, otherwise you know, yes, are you withdrawing? What I say, not necessarily that judge is intelligent, but he is sitting there, you try to understand. So he can assert, even though he doesn't know. I was not knowing anything, but if I assert, then it is very difficult for the lawyer to. But therefore, what I say, if you are assertive, you have knowledge, judge understand, I cannot take him lightly. I'll take another 2 minutes. Because question answers are also there. I was sitting in a High Court at Nagpur. One young lawyer, maybe completed 3-4 years of the practice. 3-4 years of the practice only, and was appearing in High Court. There was a law point he was arguing. I was not convinced by his arguments. I told him come next day. After 1 hour of argument, he came next day. He argued for 1 hour again. But I was not satisfied. I was little angry also, but it was not in my nature to be angry with the young lawyers. I told him, Mr. You please come tomorrow again. Next day he came, but before that when I went home, second day, I read that brief again. I read the law and I found that that young lawyer had a point. So third day when I took dais, he appeared and he said, may I start, your lordship? I told him, don't start now. You have ended your arguments. That's all. So he was scared. I told him, your arguments are over. No arguments are needed. Stop it and sit down. I dictated order which was in his favor. So because he was assertive, he argued 2 days and he was ready to argue for the third day also, because he believed that he had a point. And ultimately he convinced me. So that is needed. I don't say that that is not there in the lawyers today. That is there. On the contrary, you have more equipments today. We did not have the this laptop, mobile phone, nothing. I was reading only one book in Gadchiroli. 7 years I was at Gadchiroli. People used to ask me कि आप बदली क्यों नहीं मांगते हैं? Because no prosecutor had worked at Gadchiroli for more than 6 months. The day he is appointed, next day he applies for transfer. मेरी मदर बीमार है, वाइफ बीमार है, बच्चा छोटा है, एजुकेशन है, this that. My daughter she is present today. She was very young at that time, not school going also. So I was happy. Very small village, hardly population of 12,000 or 15,000, one magistrate court, civil judge, junior division and judicial magistrate first class. Morning session civil judge, afternoon session judicial magistrate first class. So my work was only of 1 hour daily. So what I used to do, I was getting criminal law journal in my office on government cost. That I was reading regularly and very religiously. I read Sunil Batra at that time, when we were dealing with only petty liquor cases. I read Sunil Batra at that time. And when I came to Bombay after 7 years of my stay at Gadchiroli, I first presided over Bandra Court, 12th Court. So everybody thought कि गांव से आया है जंगल से इसको क्या आता होगा. What I wanted to tell you today is that you read. Reading any law book or any other good book will help you. Everybody thought कि जंगल से आया इसको क्या आता होगा. Gadchiroli and Naxal area. So the very first day, very first remand application, lawyer appeared, argued, I granted 3-day police custody. So what was the response of lawyer? What can we do now? Judges, magistrates have become tools in the hands of police. Magistrates have become tools in the hands of police. He thought that I might not understand it because I am from Gadchiroli. So I immediately said, yes, mister, what did you say? Nothing, sir. You said something and you please repeat. No, I did not say anything. Well, you first say sorry and then you will be able to go out of court and say that you will not repeat these words in any court in future. In the meantime, one lawyer came. He is very renowned senior lawyer now. I don't want to name, it's not proper. He entered the court and said, what happened, what happened? I told him this has happened and please ask him to apologize to the court. No, sir, he did not intend to insult your lordship. At that time practice was saying worship, your worship. I said what he intended or what he did not intend is not the issue before me. He said in open court, people heard it, that I am in the tool in the hands of police, which I am not going to tolerate. I am going to initiate proceedings against him under section 6 of Contempt of Court Act, and I will hold inquiry, and if he is found prima facie guilty, I will make a reference under section 15 or of Contempt of Court Act. So then he got scared कि नहीं जज को कुछ आता है, मैजिस्ट्रेट साहब पढ़ के आए हैं. Now tell me why I was needed to read Contempt of Court at Gadchiroli, but I read it. And you see how it helped me. The very first day of my court in Bombay, the news spread everywhere. इससे पंगा मत लेना. Followed. So ultimately, whatever examples I am giving to you, whatever I am telling is the ultimate issue is that you have to read. Unless you have a knowledge, it is very difficult to survive anywhere, in fact. And wherever you go in the court, and if you are really well read, your facts on law, you are perfect, then judge has to give you time. You may get adverse order, no issue. As Rishi said, nobody went out of my court disappointed, even with adverse orders. So it is not that I am famous because I was giving favorable orders. I was trying to be well read. I was trying to be very courteous to the lawyers, particularly young lawyers. I used to tell them how to argue, what case law you can file in support of your case. These are the things. But all judges, again I repeat, I am very sorry to say that, don't bank upon judges. Bank upon yourself. Don't bank upon anybody else. Judges means I was also judge. Don't bank upon your senior also. You try to do yourself, take help of the senior. Don't feel that he will come to your rescue at the time when you are in danger. My senior once told me, you go and argue this case. It was Mr. Chaurasia was my senior at Gondia when I started practice. There was a case before Joint Registrar of Societies, but stakes were very high. So I told, no sir, you should come because the stakes, 30,000 was the stake at that time, 1978, 77. नहीं तू जा मदन कुछ नहीं होता. And I went. I argued the case. I succeeded. And the party for whom I appeared was my cousin, therefore I could not get any fee. So, dear, what I say, ladies and gentlemen, I will not say, I will say boys and girls. Nowadays, that is the, I request and I urge you that please read this book very carefully and read the books on law in whichever field you are practicing. Please try to concentrate on reading. There is no, option except reading. The laptop is for limited purpose of research. If you want to read carefully, don't waste your time on the screen of laptop, because in long run you may spoil your eyes. Take out the print. Take a book from the library if it is not with you and read it. I congratulate Rishi that such a fine book you have written, and these young lawyers are present today, and I hope that your book will help them, not only young lawyers but persons like me also, because the arrangement of the things you have done, instead of doing a lot of research, I can just take out your book and go to that particular chapter, and my problem is solved. That is my commentary on this book. Thank you very much. Thank you.
Thank you, my Lord, Mr. Justice Tahaliyani, for the very interesting and illuminating address. We learned a lot from your experiences, because experience is the most valuable commodity in the business of practice of law. I have many experienced lawyers I see in the audience also, and all of them will tell you that what's in the books is there. I mean, the law reports and the sections, and how you apply it to a specific problem in front of you. That's where the secret sauce of being a good lawyer comes across. So I just have one small anecdote to share. As sir said, that the knowledge part of practice of law, although it's a very underrated commodity, and as he said, that you cannot be assertive unless you are sure of your knowledge of law. So this is an anecdote. I met, he was junior in college, that person is no more, but he was a forensic expert and head of the KEM's forensic department. So a medical doctor, qualified medical doctor, and a professor of forensic medicine. So I said, so we were talking about Ramjit Malani, and he had a lot of interaction with him. I think I can mention his name, Dr. Paras Fatnani, late Dr. Paras Fatnani. So I was talking to him and I said, what was your experience interacting with Ramjit Malani? So he said, I'll just share one experience. Forensic medicine can be as complex as you want and as the facts come. But he said, once Ramjit Malani cross-examined me on a bruise. So just kharoch, like you walk across and you get scratched. So he said, I knew as a forensic medicine expert about bruise more when I stepped out of the witness box as compared to what I knew about bruises when I stepped into the witness box. So his cross-examine, actually he said, way he cross-examined actually educated me about the bruises, and which is an elementary thing in, medical science. It's just a surface kind of a thing. So that's, like the knowledge, application, skill. But above all things, knowledge. I mean, so thank you very much, sir, for the address. So I'll invite Sharmishtha Patil, advocate, to give the vote of thanks, and that's how the next would be. Thank you.
Very wonderful evening, all of you. Hello, I am Sharmishtha Patil. I am advocate practicing in Bombay High Court. So it is my very privilege to deliver the vote of thanks today at the conclusion of insightful book discussion on the stages in criminal trial. We are especially honored by the presence of our chief guest, Honorable Justice Mr. M.L. Tahaliyani, former judge of the Honorable Bombay High Court. Sir, your words of wisdom and your reflection from your vast experience in the criminal trial that you have already stated with us today, we have truly enriched the occasion and inspired us all. Our heartfelt thanks also goes to guest of honor Mr. Subodh Desai, sir, senior advocate, for gracing the event and sharing your thoughtful perspective on the topic of criminal trials. You have also, both of us, motivated us on lot of things. Also, the way both the expert have already explained the complexity of criminal trial stages. Also, Hrishikesh sir has stated his in poetic way. So, at the outset of this, I extend my deepest gratitude to the author, Mr. Hrishikesh sir, for presenting this important work of legal scholarship to the legal fraternity. Also, your book has illuminated the stages of criminal trials, which is in very depth knowledge and providing immense value to the students, practitioner like us, and scholars, and in growing lawyers. And I'm sure your book and our discussion today will particularly help many students, junior lawyers, my colleagues, and everyone. I take this opportunity to express my gratitude to our host, Mr. Rahul Hingmire, sir, managing partner at Vis Legis Law Practice, and his entire team, who is actually working for us behind the bars. And we would also like to thank CTAR and All India Report and his team. Your efforts in bringing together these minds under the one roof is sincerely appreciated. A special acknowledgement goes to Mr. Hasit Seth, sir, for his dedicated efforts in organizing this discussion, for generously contributing his valuable time to make this event possible. I also extend thanks to all of our dignitaries, guests, and all the students, and who all you come and gathered here. You gave us a valuable time. And also, finally, my sincere appreciation to the entire organization and his team, who worked behind the scenes to ensure the seamless conduct of this program. With these words, I again thank all of you, everyone, each of you, for present here and the support making this event more memorable with success. Thank you.
Thank you, Sharmishtha. So the program formally ends. There is tea, coffee on the other side. The books, which All India Reporter has kept a table there, they are available for sale. Hrishikesh's books are there, and they have some other books also. So I invite you to come on the other side of the auditorium so that we can talk a bit in a more relaxed atmosphere. Thank you very much, sir. Thank you.